Okay, I think we're good to go, folks.
That's the other piece. That's the other key piece. Yeah.
Do we have Commissioner Cameron?
Yes, Mr. Chair.
All right. We will reconvene the 64th meeting of the Mass Gaming Commission. If everybody will take their seats. And we will move to item number 5, item number 6, Region C. I mentioned earlier that we have the chairman of the Mashpee Wampanoag Indian tribe with us, and we've asked him, because of his stature in our community, if he'd like to say a few words, and Chairman Cronwell said he would. Welcome.
Small chairs.
Large people.
Large body, small chairs. Good afternoon, commissioners.
Good afternoon.
First of all, I want to offer my condolences from the Mashpee Wampanoag tribe to all those that were affected and impacted by the senseless violence that took place at the Boston Marathon. We as a community, as a state, will stick together on this. Very important, as a nation as well. I also want to recognize my tribal representatives, Secretary Stone, Treasurer Hendricks, Councilman Foster, and Councilwoman Trish Kalanoui from my tribal council, our tribal government, as well as our tribal elders and tribal community that have come to Western Mass for the Mass Gaming Commission meeting. Here today, I ask you, in light of all you've heard over the last 2 weeks, to reconsider your decision to open up Region C to commercial bids today, and to not open Region C to commercial bids. Since this issue was raised over a couple of weeks ago, we've received outpouring support from many people in supporting the tribal initiative, but also we've been on the receiving end of threats and insults and many things that should not be repeated, like we should have exterminated the tribe when we had a chance to. Unfortunately, this is not new to us. Over the last 400 years, we've experienced a long succession of broken promises, our land taken, our Aboriginal rights impacted, just to name a few, but we've never given up as a tribal nation. We believe we have trusted partners in the governor, in the legislature, they've worked with us to ensure hundreds of millions of dollars to the Commonwealth while respecting our tribal rights. Your plan to pave the way for 4 casinos, 2 in southeastern Massachusetts, not only undermines the legislature and the governor, but according to the state's own consultants report, which I'd like to read, a tribal Class 3 casino, and perhaps even a Class 2 casino in Massachusetts, could have a significant negative impact on commercial casinos in the state, especially if a commercial casino is located near a tribal casino. This situation would have potentially disastrous effects on commercial casinos in the Commonwealth, as tribal casinos in this case would potentially contribute no tax money to the Commonwealth and would obviously cause a decline in gross gaming revenues to commercial casinos. And that was by the Spectrum Group, August 1st, 2008. Very important information. It only jeopardizes the commercial project in Southeast Mass, but projects in every region of the state, as evidenced by the letter submitted to the Commission from MGM. I'm not going to reiterate all the different arguments that we've made up to this point, although we will continue to believe you do not have the legal authority to do this. But again, I ask you, do not interfere with the compacting process. Do not undermine the governor and the legislature. Do not interfere with our federal rights. Do not pave the way for 4 casinos. Do not put at risk hundreds of millions of dollars and thousands of jobs. Do not rush this decision today.
Thank you very much, Mr. Chairman.
Thank you.
Thank you. Okay.
Appreciate it. Thank you.
Thank you.
Small chairs, big bodies.
Okay. With that kickoff, we are here to think again about the proposition that we had on the table last, I guess it was 2 weeks ago. As usual, I think we'll start out with Commissioner McHugh to try to set the stage for our subsequent conversation.
Mr. Chairman, I want to, we had an extensive discussion last time before we elected to put the question out for public comment. about the various considerations and the various issues that were wrapped up in the decision-making process, our decision-making process, I should say. Today I thought it'd be helpful just to start this by putting up the question on which we've asked for public comment so that everybody understands what the question was, and then look at the implications of a yes answer and a no answer very quickly. The implications of a yes answer being essentially those that we discussed the last time, the implications of a no answer being likewise, and then begin a substantive discussion. So up on the board before us now is the question. The question on which the Commission has sought public comment is whether the Commission should or should not open Region C to commercial RFPs, with the Commission deciding whether to issue a commercial license to an applicant, taking into account economic and other circumstances as they exist at the time of the licensing decision, in light of the statutory objectives that govern expanded gaming in the Commonwealth. That really is a question that contains two parts. Should the Commission open Region C to commercial applications and decide the question of whether to issue a commercial license at the time the licensing process is complete, someplace down the road? The second slide that I'd like to put up there now just takes that question and deconstructs the implications of it that we detailed last week in the outline of questions and issues that we looked at. If the answer to the question is yes, then the Commission will take the following steps. The Commission will issue a commercial Phase 1 RFP. The state and federal land and trust process will be unaffected and will proceed as it has before. When the Commission issues the commercial RFP, it will simultaneously set a deadline for the responses, for the Phase 1 responses. That's the same thing we're doing now in the other regions. And again, the tribal, state, federal land and trust process will be unaffected and will continue as before. After we receive the Phase 1 applications and process them, the Commission will make, as its third step, a Region C commercial application suitability determination for each applicant, if there's more than one. And again, the tribal, federal land and trust process and the state processes will proceed unaffected and continue as before. And after the suitability determinations are made, the Commission would issue a site-specific Phase 2 RFP and a deadline for responses, and the tribal processes would continue. At some point, the deadline for the commercial responses would be received, and then the Commission, using the criteria it will use in Regions A and B, will make a decision about award of a commercial license after taking into account the economic consequences of what then appears to be the status of the tribal, state, federal land and trust process, the contents of the Phase 2 responses, the regional and statewide gaming and other economic conditions then existing, and then forecast, and other relevant considerations. This acknowledges that this entire process is playing out against a plastic fluid landscape. There are proposals, for example, now before the state legislature to approve internet poker. There are reports about the revenue streams that are being generated in various places. There are licenses that we're about to issue and licenses that will have some geographic locations that's now undetermined. So the idea of this is that the decision on a commercial license in Region C, if the answer to this question is yes, will depend on how all of those factors appear at the moment of truth, if, as it were. And based on the schedule for Regions A and B, it is likely that the Commission will be in a position to make its Region C licensing decision toward the end of 2014. So between now and the end of 2014, the state process proceeds, the tribal state federal land and trust process proceeds, the other environmental circumstances over which we have no control would proceed, and we make a decision based on all of that at the end. So that's if the answer to the question is yes. If the answer to the question is no, which is the next slide, Region C remains closed to commercial applications until the tribal, state, and federal process is completed with a favorable or unfavorable decision, or the commission is able to conclude that all necessary favorable decisions will not be forthcoming. So the Region C will remain closed until those moments arise. I suppose the commission could make a judgment later on to go through the process we're just going through now, but that's certainly not in the near horizon. So it seems to me that those succinctly state the alternatives. The yes answer will have these alternatives, the no answer will have that alternative. And so that's out there as a discussion starter. We did ask for public comments. We got a large number of public comments, many in the last couple of days since the weekend. And we got some by telephone, we got some by telephone, and some, as we'd requested, by email. All of the email responses have been posted on the web, I believe, or will shortly be. They have been posted.
All the email responses?
Have been posted on the web. And I think it's quite fair to say that the overwhelming content of those responses was give the tribe more time. And I think that is a fair characterization. They're there, they can be read by individuals, and they can make judgments for themselves. But many of them thought that this was an either-or proposition. Either you give the tribe more time or you cut the tribe's time off. And I think viewers will have to make, viewers of the email responses that are on the web will have to make that decision for themselves. But I think that is how many people interpreted the question and how they answered it. So that is a summary, I think, of the responses.
You didn't mention the voicemails.
I think the voicemails and the telephone calls were the same. I think the overwhelming response overall, I meant to say that, and if there was ambiguity, I apologize. But I think the overwhelming response was give the tribe more time in both the, and that the voicemails and the telephone calls were hard to capture as opposed to apart from a yes or no kind of thing. But I think the fair assessment was to give the tribe more time. And I think the telephone calls reflected the content and thrust of the emails. So I think it was uniform across the board. So that brings us to where we are today, and sets the stage for the discussion and the decision that we need to make today.
Just for starters, is everybody comfortable with that description of the decision process? You know, there's even been amongst ourselves, I think, at the end of last week, part of the reason we slowed down is we weren't sure exactly, even amongst ourselves, what we were talking about. But this is an attempt to clarify that proposal, not only for ourselves, but for everybody else. Commissioner Cameron, too, is everybody in agreement with Commissioner McHugh that that is the decision tree that we're facing? Okay.
Yes.
Can you repeat that, Mr. Chair? Was not clear.
I just was asking whether everybody agrees with Commissioner McHugh's sort of description of the decision tree, of the issues that we're having to address, so that there's no ambiguity about what questions we're addressing today.
None whatsoever. I think it's a very, for me, it lays the issues out and talks about what the results will be if it's a yes or a no answer. So no, I don't see any ambiguity.
Okay, great, thank you. So, let's discuss. Who's next? Commissioner
Sure, I can.
I know you have an approach here.
Yeah, I want to emphasize the point, the two-step process here that is true for everybody, that not just Region C. And some of the principles that we have as a mandate in the legislation the best time to evaluate the viability of anybody, any license in any region, is with a response in front of us. Even though there's a lot of great renderings and proposals reported in the media for all the other regions, we won't really know for sure whether any of the other applicants are proposing, or exactly what they're proposing, until the receipt of the site-specific proposal. That can then be analyzed, can be reviewed for the assumptions behind it, financial considerations, strategic plans, number of jobs, etc. So as we contemplate this process, I think it's important to highlight that the licensing point, that step 2, that is somewhere in the future for all regions, but specifically for Region C in the future, is the decision point. Now, today is not an inconsequential decision point, but I think what would be most important for us, contemplating that there's this process already on its way, the state, tribal, and federal process, that it would have, one would like to imagine, progress in some fashion between now and the point of contemplating award of a license by virtue of what's being received. So I only wanted to emphasize that as an important piece. The second piece is really that a principle for all regions, for all licenses, or all applicants, is that there's a lot of factors that go into deciding whether one applicant is better than the next.
Could I just make one clarification?
Sure.
So you're talking about what would be, if we did open for commercial and there were
Yes.
applicants, because the tribe is not an applicant. The tribe's status
Correct.
is its independent status.
That's right.
Independent of our application. So you're talking about if there were a commercial process, then the considerations about those applicants would be relevant. Okay.
Right. But I'm drawing a parallel that this is true for Region A and B as
Right.
well.
I understand that.
Because until it's sort of like when we think we can sell our house for whatever, it's all in theory until we have somebody willing to pay whatever they're willing to pay for our house if we're going to sell it. So that's a very important piece that is now in the future by the nature of the process that we require to undertake. A lengthy investigation process, this phase 2, which makes sense, phase 1 and phase 2.
And interesting, just if I may interrupt, you both have spoken to this, and I hadn't quite thought of this before, but an analogous point is what Commissioner McHugh sort of referred to. We will be making decisions on the licensees for A and B probably after we've made a decision on the slots parlor.
Correct.
The applicants, A and B, have no control over that, but it will impact our decision. But that'll be one of the many contextual issues that we will address when the time comes. Some are within the control of the applicant, some are within control of us, and others are not, and that's a perfect analogy.
Right.
Somebody's application could be prejudiced by our decision to where we locate the slots parlor, unbeknownst to them at the time of their application.
Correct.
Right.
Correct. And it's so dynamic. These gravity models. I was having a hard time trying to figure out, because unlike the example that we know well of Missouri, when they bid out the 9th license, and all other licenses were already fixed, the 3 respondents they evaluated with what the incremental license would do to the other licenses, and they were able to make good decisions based on that. Here we have a very complex, a very dynamic process in which modeling would be, it's really hard at this point. There's no fixed points. But I also want to emphasize the point that Commissioner McHugh made well, which is that we would be following the same principles if we were to open this region. On Region C, as we are on Region A and B, the same regulations. Nobody is suggesting that it would be different regulations.
Same evaluation criteria.
Same evaluation criteria. We'll be looking at jobs, we'll be looking at the finance, we'll be looking at mitigation. The thing that's important to highlight here is that there's the potential presence, we don't know when, but there's the potential presence of another a tribal operation. Some say it's imminent, some say it's much later. But any license that we evaluate, this is particularly true for Region C, but this really applies to a few of our slots parallel licensees, applicants, that are in not too far distance from Taunton. So there would be some impact in the future to those licensees, or the potential licensees. I should emphasize difference between applicants and licensees. So all of those things would have to be considered. Again, the best and only time to consider them are with a specific proposal in front of us. One that could be dissected, could be analyzed, could be questioned for assumptions behind it, could be modeled for a number of factors. So those are two key points that I wanted to talk about.
Yeah, thank you. That's interesting. Anybody else? Further thoughts?
Well, I have a number of thoughts that I want to get to at an appropriate time, but I just wanted to pick up on that, because as I was thinking about this in the last couple of weeks, I've been thinking about it, as we all have for a while, it seemed to me that obscured in a lot of the stuff that's gone back and forth is a key consideration. I think we, in our discussion last week, this may have been fuzzied up a little bit too, and that is that the tribal status and the tribal pursuit of its federal land and trust application is a fact. It's not a something that places the tribe in competition with others for a license. I mean, the tribe could, if we decide to open the Region C to commercial applications, the tribe could compete for the commercial license. In fact, the compact itself talks about that, and what would happen if it did, and what would happen if it were awarded that. So that was part of the bargaining between the tribe and the governor. But they don't have to. It's a sovereign nation. The compact is a government-to-government document, and the land and trust process is another government-to-government interchange, and so the tribe does not have to compete with anybody. But everybody, and as a consequence of that, everybody else has to make plans, calculations, and decisions around the status of the tribal application. It is a fact that is there and has to be dealt with. And so an approach that makes the decision point about a year and almost 2 years down the road, as you suggested, Commissioner, gives us the opportunity to see all of the factors as they then exist and make a commercial application decision in light of all those factors, including the fact of the tribe's progress. The tribe is predicting that it will have the land and trust process completed by then, indeed much earlier than that. And if so, that's a fact that we have to take into account and make decisions about. So it's important, I think, that we make that clear, that the tribe is not part of the bargaining or competitive process. The tribe's status is a fact that we have to take into account in making contingency plans, and that we have to keep in mind.
I also wanted to mention that a nuance along those lines, a nuance of Region C, or a difference in Region C along those facts that Commissioner McHugh articulates. Region A and Region B, we can conceivably, we can guarantee a regional monopoly. There's value because the legislation sets that forth in the statute.
Unless another tribe is recognized and gets land in trust.
That's right. But, that's right. Unless the legislature itself decides to open up to award, to give us the authority, or anyone else really, to give us the authority to award more licenses. But as it stands now, Region A and Region B, those competing for that license can be reasonably assured that there will be no other casino operation in that region. And they can make assumptions about it, and they can, and there's value in that regional monopoly, if you will. Because of what the process that Commissioner McHugh well has articulated, summarized here, but articulated before, not so much in Region C, because it has this other variable. Now, there are potentially bidders who claim that they could put a proposal in that region that acknowledges that and perhaps deals with that. I go back to my earlier point. We won't know until we have a proposal in front of us. If we have a proposal, or more than one proposal. But one would hope, and they are informed as to this process, how long it takes, what would it mean for their operation, and the fact that unlike regions A and B, there is not so much this regional exclusivity. Now, there's a timing element, and that counts, and that factors in. But there is no, in that case, for a commercial bidder anyway, a regional monopoly, I would say.
Yeah. One background data point that I don't think I've shared. In response to a letter from representatives of the tribe, I responded and told them who the consultants were that had said to us that their judgment was that our consultant's judgment was that it would be years, not months, before the casino were awarded. That was our firm, Michael and before the land and trust was awarded. That was that was Michael and Carroll. Michael and Carroll then got a phone call from a lawyer for the tribe, whose name I think is Judy Shapiro. I'm not sure I have that right. Who's been very involved in Indian law for a long time. They talked to her, I think, twice. They told me that they respected her tremendously, that she was very good, and that she basically iterated to them what has been reiterated to us, her conviction that the land and trust process is being handled very expeditiously by DOI and BIA, and that it would happen soon. And I think she said the time frame similar to what the chairman has said, which is the end of this year. And Michael and Carroll at the bottom. So the bottom line of Michael and Carroll was that meant something to them. That they thought there was probably substance behind the intent of the department to move as expeditiously as possible on this, and that might have some impact on the length of time. They nevertheless felt that in their experience, and they too have a fair amount of experience in this, it was highly unlikely that it would happen in the time frame that the tribe and that lawyer Shapiro was saying. For what it's worth, that was their reaction after talking to the lawyer. And I just want to make sure everybody had heard that. Other thought processes or analyses here, how you're getting to a conclusion? If you are.
And again, Mr. Chairman, as you alluded to earlier, we have somewhat of a clumsy process where we have to use meetings like this to brainstorm. I guess one of the initial questions or one of the initial concerns I had is that in the intervening time period between when we said we would wait 90 days, a new compact has been negotiated. I've reviewed the new compact.
The 90 days, just to be clear, there's been some misunderstanding about this. The tribe asked for 90 days to get the legislature to approve the new compact, which we did, which we granted. turns out the compact didn't get to the legislature until 90 days, but that's what the 90-day delay was for.
Right.
Right.
And when I invite my colleagues' comments or concerns about this, I have some reservation to moving the commercial process forward while there is a negotiated compact, albeit waiting legislative approval. The first time the compact was introduced, the compact had a timetable as to when it would be needed to be acted upon. We don't have that clarity this time around. I would even suggest that there are some elements of the compact, of the new compact, that if you read the decision of the BIA on the previous compact, would draw some concerns about its future into question. But I feel some hesitation or reservation in terms of, and again, I invite each of your thoughts and comments on this, as to whether we are necessarily holding up another entity of state government with proceeding with its work.
Say that
I'm
again?
not sure I understand.
What was that I didn't, that last?
I have some reservation as to, and again, invite your thoughts as to if we make a decision today to proceed with a commercial RFP application process, whether we are essentially impacting the process that still the legislature has to take in terms of scheduling a vote on the compact.
How would we be doing that? I ask that question because it seems to me, and help me if I'm misunderstanding this, it seems to me that until the point of decision, which I'm hypothesizing, it may come a little earlier or a little later, is late 2014. Until that point of decision, everything on the tribal side stays the same. And thus the commercial side proceeds as it's proceeding in A and B now. I think in the last set of discussions, the last discussion we had, the hypothesis I articulated in that summary was that the compact would be approved by the BIA by mid-August or September. I mean, one has no control, but so the hypothesis is that that would happen, that it would continue to move forward. And this time around, the BIA has given technical support to the tribe and to the Commonwealth so that it doesn't run up on the shoals that it ran up on the last time. So
Perhaps.
For planning purposes, it seems to me realistic to assume that that compact is going to get, is likely to get approved. For planning purposes, we have no control over that. We don't know. We don't know about none of these things until the end.
I would actually argue that the federal tribal process will continue even after a future decision point. But your point is well taken. I would like to emphasize one thing. Like any other license that we, in Region A and B, any other license that we request responses for, we are not required to award it. This is clear in the legislation. We are required to analyze how what good it does to the Commonwealth, and we may award it. This is not we're not a public works department, let's say, that has been mandated to request a public works project that has already been approved for funding and that ought to go to the best responsible bidder. This is not such a procurement, such a request for application. We would have to be convinced in the future that that the viability of a license commercially in that region, but any other region, is viable, and that it brings all the benefits that we're forecasting and others are forecasting and are set forth in the legislation. So, taking a step today or any time in the future towards opening a region for requests for applications does not bind this commission really to have to award it. I think that was obvious, but I think it bears repeating that this two-step process does not and should not undermine any efforts by anybody else, whether it's the other agencies, the legislature itself, or the federal tribal process. But I think that was already summarized.
Yeah. In response to the question you're raising, Commissioner Stebbins, it seems to me that I don't know whether it'll affect. I don't know what it will do. I mean, I don't think there's any way to predict what our action or lack of action, whatever our decision is, will have on the legislature. I simply don't know how we could calculate what that is. I think that you can look at our experience on the 90-day delay. The compact didn't get signed until the day before our meeting that we set at the end of 90 days. If we hadn't set that deadline, I don't know if there'd be a compact. I think having us take the ball and make decisions does, in fact, at least in some quarters, trigger action. It's maybe action and reaction. What the net of that, I don't know is, but somebody has to act here, and it's we. And I think that to predict what the action will be is impossible. There may be a reason to predict that some action is more likely to happen if we act than not. The other thing, and this is just for myself, to me the issue is not the compact. The possibility that there wouldn't be a compact was so unanticipated that the legislature never addressed it. Never addressed the possibility that the compact would not have been approved if it was approved by the legislature by July 31st of last year. Right. That's not the issue to me. I assume the compact will get, or at least I'm happy to assume, the tribe tells me it'll get done, so I guess it'll get done. I don't know. That's not the issue. The issue to me, the real unknown, that's the fly in the ointment here. If the question were, land and trust is a no-brainer, it's going to get done if the compact is, assuming the compact gets done, I don't think we'd be having this conversation. The issue is land and trust. So whether the compact were done or not, I at least would still be entertaining this conversation.
Yeah, I want to pick up on that and just go through, if I might, for a second, the thought process that I've used here. It seems to me we have to start with and I go back to Chairman Cromwell's thoughts. Have to go back to our power to do this, and I simply read 91E differently. If 91E prohibits us from doing this, it's game over, and that's a simple question of law. It can be decided quickly. I just don't think that it does, and I've articulated that before you. So you start with the proposition that we have discretion to interpret the statute. This is a fair reading of a statute that is within our jurisdiction to enforce. And that reading is that we have the power to open commercial bids. We must open them under certain circumstances, but we may open them under others. And so we start from that point. We've discussed the compact issue, and I have nothing further to add there. I'd proceed on the assumption that it will be executed, but the land and trust issue is the issue. And in that issue is the Carcieri decision. That's one of the big problems in there, and I know that it's been said to be a top priority. I know that it's been said to be something that the solicitor is considering actively, but that is not going to be the subject of a separate announcement, according to what Kevin Washburn said to me in the phone call that I had to him. That's advice to him that will find its way into the overall trust decision. The legislation, as I view it, manifested an intent, and this is an intent that is determined in the normal way by looking at the structure of the statute, the language the legislature used, the clear problems with which they were trying to deal, the legislature manifested, it seems to me, a general suggestion that Regency not be left behind, and gave the commission discretion as to how to ensure that Regency was not left behind in the event that the tribal processes, thoughtfully and aggressively and carefully pursued as they are being, ultimately failed. That's something that the commission has the responsibility to look at and the discretion to deal with in a what-if danger mitigation fashion. But importantly, I don't think waiting is an option. We're defendants in a lawsuit in the federal court now. The First Circuit has made a decision, the last 7 pages of which talk about how the longer we wait without an undefined deadline, the more the wait begins to look like a violation of the Equal Protection Clause of the 14th Amendment. And so simply doing nothing, it seems to me, feeds into the clear indication. The First Circuit didn't decide that issue, but the longer we wait without some kind of a plan for allowing events to proceed to a predetermined decision point, one of which is supporting the IGRA process, which a wait will do, the more the wait is simply undefined, the more it looks like it may be a violation of the Equal Protection Clause. And we can't tell with certainty, unless we take some step, how long that wait will be. As the First Circuit pointed out, the compact contains a provision saying that in the event that this land and trust application is unsuccessful, I know the tribe believes, and one would hope that they're right, that that's not going to happen. But if it is, then they have the right under the compact to find other land and start a new land and trust process with respect to that other land. So the wait is not necessarily terminated by a negative decision on this land and trust application. It would be terminated, of course, by a positive determination, but the tribe has already predicted when that would happen. So it seems to me that taking a position that allows the tribal process to proceed and at the same time sets us up to take a look at whether to issue a commercial license at the end of a generous amount of time is really the best course to take. That allows the tribe to move forward unencumbered, allows the tribe to continue its process, and if its projections are correct, by early next year, their application, their land and trust processes will finish, and they will have land in trust and can proceed with the construction that they've been planning and working on with the citizens of Taunton for so long. Opening up the commercial application doesn't automatically reduce the Commonwealth's share of gaming revenue. Even an award of a license doesn't do that, because under the compact, the share of the Commonwealth's share only drops if another casino actually commences operation in the same region. So the mere fact, the step we're taking today doesn't affect the potential for that full 17% from the tribe's license, from the tribe's operations that come to the state. On the commercial side, we're not proceeding on a parallel track the way we were in the past, in the sense that if the tribe's successful, we automatically stop the commercial side. We're going to look at the commercial side on a functional basis in essentially the same way that we're looking at it elsewhere. And that's an option, that other option, the parallel track one, was one we discussed in December, but this is different. We look at all matters as they exist at the time of the decision. We take a look, as you've so well articulated, Commissioner, at things in the same way we've looked at them in other regions. We have in our application evaluation criteria said that all applicants have to present us with an economically viable proposal, and that we're interested in new revenues rather than revenues that cannibalize existing businesses. So we have to take into account what is an existing business at the time of our decision, and whether the viability of the applicant would depend on cannibalizing revenues that are going to that business rather than pulling in revenues from another place. And if the tribe is there, that's one of the businesses that one would have to consider. And we have to consider all the criteria, including the one that we all know and cannot ignore, and that is the question whether Region C can support 2 casinos and the Commonwealth can support 4. And all the studies suggest it can't. So we're not ignoring the 4 casino warnings that we've been well apprised of and have considered through this point. So it seems to me that in terms of mitigating the risk, allowing the tribe to proceed, recognizing where the tribe has gone, allowing it to continue that process, but at the same time doing a realistic bit of planning for what happens if the tribe is not successful, is the responsible thing to do and is a sound exercise of our discretion under the statute and a sound way of fulfilling our statutory obligation to look after all the citizens of the Commonwealth, tribe included. The tribe, I think of as an important part of the Commonwealth's history and population. So I think this respects everybody's rights and is a sound way of exercising the difficult responsibility in this area that we have. So I would be in favor of doing this.
Commissioner Cameron, do you want to add your?
Yes, Mr. Chair. Once in a while, I do have an opinion. This is a difficult issue for me. I very much respect the tribe's right to proceed with this process. And I had to understand that, in fact, this plan that we're contemplating does, in fact, respect the rights and the ability to move forward. The other issue I struggled with personally was the legality. What's realistic and what does past practice show us about land and trust and challenges after the fact? And I know one of the letters from the tribe's attorney urged us to reach out to gaming who had knowledge of tribal gaming process. And I think we've done that. I know I spent a lot of time speaking with our gaming lawyers who really walk through these issues with me. Past practice, what's probable, what has changed. I also spent time speaking with our own legal staff about different pieces of this process and what it meant and our ability to do this. So after, educating myself as to a place where I can feel comfortable, I am supporting this plan. I point out the fact that it was important to me that the tribe had the ability to move forward, but it's also important that we as a commission look out for the region as a whole. And I was persuaded by comments from citizens and legislators about Southeastern Mass and the need for this kind of economic development and not falling behind. So, after really wrestling with all of these issues and understanding it, I believe I am in support of this plan for the reasons Commissioner McHugh just articulated, and in speaking with people who I think have real knowledge of this process and time frames. And it does allow us to move forward and see how these things play out. And Commissioner Zuniga's point is well taken as well about seeing the quality of the bids and not having the obligation. If there is what is best for the Commonwealth, and I believe this plan will allow us to see that. That's something we can't do now with the status quo. So I am supporting this plan. Thank you.
I'd like to do what everybody else has done, which is walk through my thought process. It's hard for me as well. Would that the legislature had given us clear signals on this. I don't think they did. For me, the fundamental issue is the inability to tie down with any degree of certainty when the land and trust issue will happen. The tribe says with emotion and conviction that it will happen soon. Others say that it's a long time away, and I personally have no way to come to a conclusion as to when it is likely, when it will happen. I believe, as Commissioner McHugh said, that we have the clear authority to do this, but that is a matter of law which will be decided if somebody chooses to challenge that. The law does say, as Commissioner McHugh said, that under certain circumstances we must issue an RFP. But that is if, quote, the commission determines that the tribe will not have land taken into trust by the U.S. Secretary of the Interior. If the commission determines that, the commission shall consider bids for a Category 1 license in Region C. For us to determine that the tribe will not get land taken into trust by the U.S. Secretary to me is an impossibility, because at any time, Congress could make that decision. And maybe the Supreme Court could make a decision. It's an impossibility for us to come to that conclusion, which suggests to me that there is a sense of some degree of reasonableness, some degree of arbitrary authority on or independent authority on our part to figure out how to deal with that ambiguity. So then I try to think through, okay, as I said the other day, there are no good solutions here. There's only trying to figure out the least bad solution. So as I walk through the different alternatives, if we wait on the tribe for, I don't know whether it's the end of the year or early 2014, but whenever they say the land and trust application happens, and that fails, and that deadline, promised deadline, is not met, the Commonwealth loses the $85 million license fee from a commercial applicant. The Commonwealth loses $100 million or so in revenues for every year that this unknown delay goes on, and the Commonwealth loses whatever the economic development and jobs impact is of the construction of a commercial facility. If we proceed and the tribe succeeds on the schedule that they say they will proceed on, then I think there's a substantial likelihood, for a host of reasons, some of which I'll speak to, that when we get to our decision point, that we would go with the tribe's proposal. The commercial bidders will have misled us. The commercial bidders will have premised their application on something which turns out to be false, that the tribe will take years to get their land in trust. And they might well, there's no guarantee of this, but the commercial bidders, having misled us about how long land in trust will take, may well lose at the end. If we proceed and the tribe fails to meet its deadline, as they have said they can meet, then we will have selected a commercial alternative, and Southeastern Mass interests will have been protected. It seems to me, and I understand where this is where I sit, and there are folks in the audience who sit in a different place, but it seems to me that amongst these undesirable options, the tribe has the least to lose of all of the invested parties of us going forward the way that we're going forward. The tribe actually the tribe has the opportunity to win. If the tribe does what the tribe says it will do, it has by far the best chance to end up getting what it wants. And that is a powerful head start. There's one other point here that I wanted to make. If we go commercial and the compact, and the tribe gets the compact approved, just the compact approved, there may well be no commercial bids. And I quote a letter from KG Ehrman, the only identified interested commercial party at this point. They said the proposed contract, if approved, will choke off competition, even if the region has been opened by the commission due to the unnecessary and absurd economic advantage being provided to the Mashpee. Now forget unnecessary and absurd economic advantage. That would just be, ignore that part. But KG Ehrman says that the mere approval of the compact will, in its words, choke off competition. So no matter which route we choose, it seems to me that, to use a figure of speech, the Mashpee holds the best hand down any of the routes that we choose, including the one that we are contemplating today, with the most options available to them with the least prejudice to their long-term case. If they perform as they say they will, with a compact and land in trust this year, they very likely will get what they want, no matter what else anybody does. So I, too, conclude that I reiterate, among unattractive options, that going with the plan that we've got on the table is the right way to go. Commissioner Stebbins, anything else?
No, I appreciate the input and the thoughts of my colleagues, and I appreciate their viewpoints.
Okay, any more discussion? Commissioner
To
Zuniga?
summarize my position, like others have done, I would also be in support of answering yes to this question as posed here today to open the region and see what proposals may or may not come and how they come, if that's the case.
Any other comment, discussion? Commissioner Q, may be best to have you tee up a motion.
I move, colleagues, that the commission open Regency to commercial RFPs, with the commission deciding whether to issue a commercial license to an applicant after taking into account economic and other circumstances as they exist at the time of the licensing decision, in light of the statutory objectives that govern expanded gaming in the Commonwealth and the discretion with which the expanded gaming statute clothes the commission.
Second?
Second.
Any further discussion? Okay, I will poll the commission. Commissioner Stebbins?
Yes.
Commissioner Zuniga?
Yes.
Commissioner McHugh?
Yes.
Commissioner Cameron?
Yes.
And the chair also votes yes. The motion passes unanimously. I think that is our last item. Any other business? Thank you, folks, for coming to join us. Sorry about the technological problems, and we wish you all well. I guess we have a motion to adjourn.
Motion moved.